Right. All right, Mr. Dutton, you're up.
Thank you, Your Honor. Scott Dutton here for the appellant, United Services Automobile Association. And Your Honor, I'd like to set aside 5 minutes for rebuttal time. Thank you, Judge. And let me start out by, this is a 57105 matter that spins out of a personal injury protection case. And in order to get a full grasp of why we're here, I'm going to go through a timeline for the court that I hope will be of benefit to the court. This case involved an August 16th, 2015 cause of action. About a year later, the insured, Ms. Schneider, went to the plaintiff's facility, SunCare, on August 26, 2016. And as a result of that visit, SunCare billed 2 CPT codes. One CPT code is a 99204. That's an evaluation and management code. That's when you go see a doctor or physician for an initial visit. It also billed another code, which was 95851, which is a code that associates itself with range of motion measurements and report. It is by itself a separate procedure from what's done during an evaluation and management. And what's supposed to happen is that you're supposed to take the patient to certain ranges of motion and make certain measurements during the course of range of motion, do a comparison to what's within the range of normal, and report those in a separate and distinct report from the evaluation management. I'll share with you that there is no such report that I've seen that ever exists in this record, and none was ever presented by SunCare in this particular case. So what happened is when the charges were ultimately submitted to USAA, that was received by USAA in early September. On September 22nd, 2016, USAA made payment of the 99204 at the fee scheduled amount, which in this case was $331 times 80% or $265.22, and generated an explanation of reimbursement, which is what comes with typically when a patient goes to a facility such as SunCare. The facility then generates what's commonly referred to as either an explanation of benefits or an explanation of reimbursement. The explanation of reimbursement in this case is important because it not only told them that they were reducing the 99204 charges pursuant to the fee schedules, and this is what it says, per FSA, Florida Statutes Annotated 627.7365A1F, services and supplies are reimbursed at 200% of the applicable Medicare Part B fee schedule. The second part, however, that is for the range of motion testing, it said, in order to make a reimbursement decision, the daily treatment notes, tests, and measurements are needed to support the services provided. That then goes to plaintiff and asking, or the SunCare asking them for that information. Again, the daily treatment notes, the tests, and the measurements are needed to support the services provided. And that's in order to make reimbursement. One would have thought that if SunCare wanted to be reimbursed, they would respond to that. That type of request for information is statutory.
Well, let me stop you right there, though, Mr. Dutton. We're not really here on the question of whether there was an obligation to furnish that information. The question is whether the plaintiff's attorney knew or should have known that their lawsuit was premature, basically, correct?
The provider or the plaintiff's attorney.
I get it, but that's what the issue is. And that boils down to the interpretation of what you say is the statutory requirement to under, what is it?
627.736 sub 6B.
Yeah, you have that memorized, don't you?
Well, you know I do, Judge.
Yeah, because I don't do this work every day like you do. So, which may change, right? Because of the jurisdiction change.
We seem to be seeing each other more and more, Your Honor.
I know, and I always look forward to it. I really do. But the request that you just read to us was not furnish a written report of the history, condition, treatment dates, costs of such treatment, blah 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 blah. You know, and that's with an and, right? And pursuant doesn't say pursuant to. You can recite the statute. So the question, I think, the provider side says, you know, we didn't necessarily think that it was under that statute such that it extended the time for payment.
First of all, this is obviously a provider that needs to either know or should know what the personal injury protection law requires.
Well, yeah, except that's the thing. The law, that statute, the request doesn't really recite that statute. The request said, send us some documentation about this claim, basically, kind of informally. Well, it seems informal.
And it doesn't have to do that.
The statute says,
does not have
to this section, which could be arguably could imply that you could make these requests for information outside of this section. And I'm not here to argue, because you've given us a lot of case law from the circuit court level interpreting that statute. The question is whether this comes to a 57.105 level of knew or should have known that the claim had no basis in law or fact because it was premature.
So let me start with this. There's nothing in 67.736 sub 6B that says you must recite the statute. Let me give you a comparison.
Oh, I agree. And that would make things a lot clearer. What it does say, though, is pursuant to this section, under this paragraph, within 30 days, you know, if you make a request for documentation or information under this paragraph. And the request here was far less than what the statute says that the provider must furnish. It didn't say we need a written report, sworn statement, you know, all of your records regarding history, condition, blah, blah, blah. And those are ands. The statute says you don't request one or the other. It says upon the request of the insurer, you have to furnish all of this stuff pursuant to this paragraph. And the request here was far less, you know, didn't seem all that formal. I mean, you know, you read it, and it's not that I'm saying it's unreasonable. What I'm saying is the question is can a judge sitting here, can a judge entertaining a motion for 57.105 fees in which the judge to grant the fee would have to require that the party knew or should have known that the claim was not supported by law or fact? Wouldn't the judge conclude as a matter of discretion? Well, you know, it's not necessarily clear that this triggered that statute and the extension on the time to pay.
And I'm going to respond to that in multiple ways. And the first
it's kind of a multiple parts too. I get it, but
the first thing is I want to share with you that there is appellate case law in this state that says you don't have to ask for everything you could get under 6B.
I understand that. I understand that. That there's some case law that says that, none out of this district. But you know, and I fully understand that. But the question is what is reasonably resides in the mind of the party for purposes of 57.105.
So,
because you haven't given us, you guys, both of you, cited a lot of cases out of circuit courts and so forth, and there are only a couple of them that awarded 57.105 fees, and neither of them have to do with this issue, correct?
Well, not 57.105, not that I'm aware of, that relates specifically to a failure to respond to a 6B request for information.
A failure to appreciate that it was a 6B request. That's the point.
And consequently
filing a premature lawsuit.
So this is what it says, and the insurer is telling you this, that in order to make a reimbursement decision, in other words, in order to do or pay,
We want this information. I get it. Yeah.
the daily treatment notes, tests, and measurements are needed to support the service provided. So they're telling you you need that. And so there's nothing in the statute. This is where I was headed regarding when you need that. For example, if you go over the demand letter statute and you specifically look under 627.736 sub 10, that's the demand letter statute.
Yeah.
Sub B, it says the notice must state that it is a quote demand letter under 627.736 close quote. So in other words, when legislature requires that sort of language, because let's suppose I was setting you for an independent medical examination. Do I have to say I'm asking you for an independent medical examination pursuant to that section of statute?
Mr. Dutton, I get it. I get it. And you know, I get your point, and I'm not saying it's incorrect. It may well be correct. The question is whether when the request is a lot less formal than this statute appears to require or suggest, that, you know, the information requested is a lot less than the statute says that must be required under it, whether a party knows or should have known that this statute and the extension of time for payment was implicated. That's the question. And whether a trial court who decides that the showing isn't sufficient for 57105 fees has abused his or her discretion. I don't remember which it was in this case, but that's where we're at. I mean, you know, I can't disagree with your interpretation of the statute.
Let me say this, that what they're asking for is an extension of the law. That is, that you must specifically reference 627.7366B. That doesn't exist. There's not one case that says that the request for the information must specifically reference the statute, just like it doesn't have. Go ahead. I'm sorry.
Well, yeah, I mean, I guess I don't think they're asking us to extend the law in that respect. I think that they're saying we should find that the judge didn't abuse the discretion in assessing the 57105 claim.
Well, if they had come forward to the court with any case law that said that that's the case, but let
I don't think that's true either. You know, you come up with a case that's not out of the second DCA or a case that's not out of any DCA. I'm not sure it's binding, and it could be arguable. I mean, okay. I could stand at the podium like I did a lot of years, as you know, and argue that when it says pursuant to this paragraph, those are meaningful terms of art. And so it's not clear that the request for, you know, it implies that you can make a request for information outside of this paragraph.
So here's where I'm going to take you, John. I'm going to take you to a case that I was actually the attorney at the trial court level.
I mean, you were the attorney on so many of these cases, Mr. Dutton. Yeah.
And one of the appellate attorneys at the appellate level. But here was the challenge to the court. And this is admittedly in Palm Beach County, but it goes to the 4th District. And I believe it is binding on this court because it went to
unless we disagree with it.
And then that will open the door for but the point is, if you disagree with it, that's prospective. This is the law that existed at the time. And so let me share with you what I'm going to read for you is a 2014 court order. And that's what it says. In the defendant's explanation of reimbursement for plaintiff's charge at issue, and the one I'm reading from is an EMC case, emergency medical condition case. Right. The defendant clearly notified the plaintiff that the statutory policy limits of $2,500 have been paid and requested the plaintiff to provide information regarding the determination of the claimant's emergency medical condition by a medical provider authorized or qualified in 67.736(1)(a)(3) in order to justify any additional reimbursement. The court deems this statement contained within the explanation of reimbursement is a request for information pursuant to 627.7366B regarding the history, condition, treatment, dates, and cost of treatment. And as such, the statement holds the time when the charges are due or overdue. The defendant's explanation of reimbursement clearly states that in order for the defendant to make additional reimbursement decisions above the statutory $2,500 reimbursement limit, that the plaintiff needed to provide a determination of the claimant's emergency medical condition by a provider authorized in the statute. The fact that the explanations of reimbursement do not specifically reference 627.736B Florida statutes, or the fact that the request is not contained within a separate or distinct letter is irrelevant. That is not required by the statute. Moreover, the request for information could not be clearer. In fact, the request for information, if the request for information is just cited to 627.7366B, it would be less clear than spelling out what information the defendant required to make additional payments. Now, what did the fourth district?
Here's the thing, Mr. Dutton. I submit, I could write a very nice opinion suggesting that that interpretation of the statute is incorrect. Okay, and I don't know that that issue is before us, because it might be before us had the judge agreed with that was at the fourth ECA, I guess, out of Palm Beach. If the judge had agreed that that was binding and that the plaintiff should have known that, and therefore 57-105 fees were appropriate in this case and awarded them, the correctness of that interpretation by the fourth ECA would be squarely in front of us. But I don't think it is.
And so here's the question, though, and this is what goes to the fourth, and it was on appeal, specifically that provision. And it says, we find that USA had the right pursuant to 67.736B to request a written report of the insurance condition. And then it goes on and talks about the statute, and based upon the plain language of this subsection, as well as the title of the subsection, it's clear that the focus of this provision is the discovery of documents regarding the treatment and related billing of the individual injured, cited the State Farm versus Delray Medical. That's also out of the fourth from 2015. These are both older opinions, but the point is that the statute's clear that it empowers the insurance company to use it for informal discovery when it needs to have information.
But nowhere does the statute actually say that. So what you're saying is because the court interpreted it that way, they should have known, they knew or should have known that their claim had no basis for purposes of section 57-105.
Because they had no case.
That's the basis. That's
just remotely that opposite. They had nothing that says you must tell them specifically that this is being made pursuant to 60 or else it fails. No,
that's not what they said. What they said was they didn't think that this informal request for documents was implicating this statute, and you know, I've argued with you obviously into your rebuttal time, so we probably ought to stop. But
well, and there's a whole nother grounds that's separate from that, as you know, and that has to do with the pre-suit demand, because the pre-suit demand, because there is controlling authority in the 13th Judicial Circuit that is directly on point.
Not controlling out of the 13th Circuit. See, that 13th Circuit decision don't control anything.
It did when this case was before Judge.
Didn't control. One circuit judge's opinion doesn't control the other circuit judge's opinion.
It's an appellate opinion, and there's not an appellate opinion to the contrary. In fact, there are two in the 13th Judicial Circuit.
It's a circuit court appellate decision that any circuit judge can disagree with. I'm telling you. All right, but we got to stop.
I agree. Circuit panels could disagree. I'm just telling you, there's not one that does.
Right. We got to stop so we can. I'll save your 5 minutes because I really, argued with you. We're all friends,
But thanks for the opportunity to debate.
Yeah, really. All right, Mr. Lee.
Yes, Your Honor. Thank you. And my name is Brian Lee. I'm representing the appellee in this case. I think it's important to start off with what is the issue in this appeal, and it's the trial court's order. The trial court in its order, this is found on page 812 of the record, says after the trial court talks about a little bit of the litigation, says the court finds that the evidence as presented by defendant, that would be the appellant
Okay.
in this matter, is not sufficient to meet the burden under section 57.1051. And then he recites that. As such, defendant is not entitled to an award of fees under section 57.105 in this matter. So when we're talking about the issue on this appeal, it is whether the trial court abused his discretion in making that decision. Obviously, the trial court had all of the information in front of it. When it did that, all the filings, all the memorandum of the party, and the trial court determined that based upon that evidence, there was no there was no stand. I'm sorry, Judge, did you say something?
I just said, or in this case, abuse her discretion.
Or discretion.
Correct, Your Honor.
Judge Over.
I may have said he, but that's true.
Yeah.
And so when we look at the law on this particular subject, 57.105 motions, even with the change now in the standard, it says it must be applied with restraint. This is this court in the McAllister case. Must be applied with restraint to ensure that it serves its intended purpose of discouraging baseless claims without casting a chilling effect on use of the courts. So that's this court talking about when 57.105 motion should or should not be used. When we look at the specifics of this case, there is two main focuses. There's the request that the appellant believes they made under section 6B, that of course the court's been talking with the appellant's counsel regarding. And then there's also the demand letter that's there. And so I wanted to just briefly talk about the 6B part of this analysis. The cited, the actual explanation of reimbursement form that was actually counsel read to the court. One thing that's interesting in that, and I put this in the answer brief, is that the appellant actually cited specifically to another statute when it was talking about reducing services. If you recall, it was read to you that they cited to the specific statute that says, here's why we're reducing benefits. However, there's no statute that is cited as far as, and it's really not even labeled a request, so to speak. And when we look at the statute in question, and I think Judge Northcutt already read part of this. Part of that statute says that if an insurer makes a written request for documentation or information under this paragraph, meaning that there is some type of request that can be done under this particular paragraph that then triggers a provider's duties under that. And they're spelled out in section B of that. There's a lot of different things that a provider has to provide. It uses a lot of shall language, as I have put it before. And so when we're talking about a request under this paragraph, there is certainly an argument that that request has to be a specific request. And the reason that is because then it triggers certain responsibilities from the provider. And so in this case, it is undisputed that none of the explanation of reimbursement requests, none of them had any language whatsoever regarding this particular section, certainly under 6B. The case law.
What do you say though to Mr. Dutton's argument? And I agree. The statute seems to go far beyond the request that was made. And requires a sworn statement, et cetera, and so forth. And these are not or. This is and. However, Mr. Dutton points out, there's 4 DCA cases that say, they just call you, if they send you, it's got to be in writing. When they send you a letter saying, well, just give us these couple of things, and that's all it says, that's good enough under 6B.
I believe we're talking about one particular case, which is the medical center case, which was cited.
Right.
The other cases that are cited in their brief, I'm taking medical center aside, I'll get back to that. The other cases talk about that when there is a request, meaning an actual bona fide request, yes, you do have to provide all those things. Those are the duties that you have as a provider under that statute. Yeah. The medical center versus USAA case, which is cited to, There's a couple of issues with that case. Number one, as the court's already said, it's a fourth DCA case. But besides that, the question that was
It's a fourth DCA case that was binding until this court or the Supreme Court said otherwise.
well, that's correct, Your Honor. But I think the main issue that I wanted to point out to the court is that the issue that came up on appeal to the Fourth District Court of Appeal was not the issue of a 6B request. The issue was clearly under the other provision they were talking about, which is 627.7361A4. Because when you look at this particular case, the fourth DCA case, it actually sets forth the question that the trial court put to it. I'll just read it for ease. Yeah. In an action by an assignee for no fault insurance benefits under a policy of motor vehicle insurance, are benefits above $2,500 only available where there has been a determination by a medical provider authorized by statute that an emergency medical condition exists as defined in the Florida no-fault law. That's it. That was the issue in front of the fourth DCA. There was nothing in that issue regarding a 6B request. Now, I will say later on in the decision, the court, as it's talking about that issue, does say, we find that USAA had the right pursuant to section 6B, I'm going to shorthand it, to request a written report on the insured's condition. They then cite the provision and then say, in the instant case, USAA appropriately requested a report on the insured's medical condition. That's the wording that's seized upon by the appellant. The problem is there's nothing in that fourth DCA opinion that talks about the request. Doesn't say what the request was, doesn't say what it did, doesn't say what the wordings were. And so for the appellant to say that somehow this fourth DCA case is now binding on this court, number one, it wouldn't be. But for the trial courts, it's on an issue that wasn't brought up at all in this case. And it's talking about what I would think would be, if not Ditka, would be something opposite of what the issue was. And
doesn't really go to the question whether you would necessarily know that what appeared to be a fairly informal request was actually triggered the extension under 6B.
Correct. And there's nothing in the opinion itself that talks about the request. And I think the reason that is because it wasn't the issue.
Could you address Mr. Dutton's, Mr. Dutton pointed out that there's a problem here with the demand letter and the amount that was being demanded.
Certainly. And I'll refer to
you have a 57105 fee, a case that's been cited to us that involved an inaccurate demand letter. We don't have one. We don't have one that involved the 6B issue, but we have one that talked about an inaccurate demand letter that was sent as a precondition to the suit.
Right, and the way that I would speak about that, Your Honor, is that as we've put in the brief, the pre-suit demand. I think as the court has seen through the citing of cases back and forth, there was a lot of indecision, frankly, in the trial court's levels of whether or not the pre-suit demand needed to have the specificity that the appellant says that it should have. There's cases that we cited, there's cases that they cited in there. I actually wanted to refer to the case that the appellant actually provided to the court, which is a supplemental case. Obviously, this would not have been binding, of course, on the appellee's counsel or the appellee themselves, because it was literally this year. But I think it is instructive to the court as to what the state of the law was at the time, and that's the Rivera versus State Farm case that was filed by the appellant in this case. In that decision, it actually talks about the specificity provision of the pre-suit demand. And what it says in there under the analysis section, it says, and I'm quoting, Florida county courts, circuit courts, And the appellate divisions of circuit courts have varied in their reading of the statute and the specificity required by section 627.73610. Many have interpreted the language of that statute to require a strict construction of the statute, and then it lists some cases. Then it says, but others have interpreted the statute's requirements more loosely, and it lists those cases. Some of those cases we've listed ourselves. And so even in 2021, when the third district was looking at this issue, it acknowledged that there was this split of authority amongst the trial courts, not just the trial courts, the county courts, as well as trial courts acting in their appellate capacity. And so to say that there was some known element of the law that everybody was on the same page, and that the appellee's counsel or the appellee themselves should have known that that was the case is just not there. And the third DCA tells us very specifically that was now. Now, obviously, the third DCA then determined for themselves that specificity was required. But that certainly was not present when this was going on. And I did want to mention one thing before I forget. The issues that we're talking about, the 6B issue, the pre-suit demand issue, those were all part of motions for summary judgment. They did not come to fruition because the appellee voluntarily dismissed the case. And we've put in there, and you've seen, I believe, the argument as to why that was done. Although, dismissals can be a foundation for sanctions, I don't think that the appellant's arguments are correct in this regard because of the fact that the appellant is acting as though there's been some adjudication of these matters, that the trial court in some way had adjudicated the issues, that they won those issues, that their reasoning was correct. That did not happen in this case. The only thing that the trial court determined was whether the evidence that the appellee and their counsel had during this entire time frame was sufficient to go to 57-105 sanctions, which, as we know, are extraordinary sanctions. It did not. The trial court clearly said that the evidence did not rise to that level. And there's nothing in the appellant's briefing or their arguments to the court that shows that, because the law, even now, as we're sitting here, even with the benefit of the decisions, as far as the 6B decision, that law is not settled. As far as the pre-demand letter, the law is settled in the third district now. It's not settled in this district. And so this district has never gotten to those issues. And this case is not for this district to get into those issues as well. It's just not the issue in front of this court. Unless there's any more questions that any of you have, I was just going to say we believe that the trial court did not abuse its discretion and would ask that the court affirm the order.
Okay, Mr. Dutton, I just want to ask you one question, and just,
Sure.
Again, we've waded through a lot of, but you guys have both cited us a bunch of cases, primarily circuit court cases. And as I looked through them, I've only found 2 that awarded 57-105 fees. Do you have any case, and have I missed one, where an appellate court or a circuit court sitting in its appellate capacity has reversed the denial of 57-105 fees as an abuse of discretion under these circumstances?
As it relates to
6B request or the pre-suit demand letter?
I can't think of one that comes to mind with all due respect, but I'll certainly, if one is clear,
you'll be sending it to us.
But I will say this, and we did point out that in 2018, there was a case from Judge Gaston Fernandez that was pretty much on all fours, where whose work we review as an appellate court. I'm with you. But let me back into this. First of all, we talked about chilling effect. My client had to litigate this case for a year and a half to make it go away. And it should have gone away from the very beginning because they never gave us the records ever up until the conclusion of the case because they didn't exist, evidently. And then number two is that the laboring through all of this, we sent them 57105s. 2, we sent them motions for summary judgment. 2, we give them insurance policy. We do all of these things for a year and a half. And talking about chilling effect, what's unfair.
But did you set those motions for summary judgment for hearing?
Oh, that's a great question.
Because you couldn't get a hearing. You couldn't get a hearing.
They wouldn't have said it. So we had and when that occurs, instead of unilaterally setting it, we set a motion for case management, go to case management. They say they need to depose the adjuster. They then depose the adjuster, and within about a month or so after they depose the adjuster,
voluntarily dismissed. Yeah.
So, yeah, I wish we could have, because they have no evidence, never put any evidence to the record. And that's the thing that we talk about abuse of discretion. We put all the evidence in, they put nothing. And so there's nothing where a court could weigh the evidence and go, well, they had this or they had that. But I really do want to get to, number one, the medical centers case. I do want to point out again, I was not only the trial attorney, but the appellate attorney. And I can assure you that if you look at the briefing in the case, that one of the issues before the 4th District Court of Appeal is whether or not the language that I read you from that EOR was sufficient to establish 6B, and the court did rule on that. That's why it says it in the opinion. So while they were looking at the EMC issue, they were also looking at 6B, and also part and parcel of that same issue we raised, it made the pre-suit demand premature. But the cases that they talked about, let's talk about the pre-suit demand real quick, and I don't want to run out of time. Because
you still have like 3 minutes ago.
Thank you, Your Honor. The binding authority in the 13th Judicial Circuit appellate had been long-standing and is cited repeatedly by courts all over the state is the Chambers Medical Group as assignee of St. Hilaire versus Progressive Express from the appellate court. This was written by Judge Holder, and 14 FLW sub 207A. Again, this is binding appellate authority, and there's nothing in the 13th Judicial Circuit to the contrary. And in this particular case, few issues that struck home here. Number one is, did the pre-suit demand contain an itemized statement specifying the exact amount? It didn't. And the reason it didn't is because it didn't take into consideration amounts that had been paid. And so the court said because the pre-suit demand did not take into consideration partial payments, it was an invalid pre-suit demand. It also pointed out that it requires strict compliance. And where I want to get is when we go to this Rivera decision, yeah, the plaintiff pointed out all these Duval County court cases, but he has binding authority in the 13th that he's bound to point out to the court and go, yeah, but this would have been binding on Judge Ober at the time. And there are multiple court orders. In fact, when I pointed to the Conforti case with Judge Fernandez, if you read page, the legal analysis discussion, paragraph 2, this court's bound by the opinion issued in Chambers Medical Group. So are we going to tell courts, trial courts, not appellate courts? I agree with you. Appellate panels at circuit level can differ, but not trial courts. They had to follow the case I just cited to you. And so when we get to the Rivera case out of the 3rd District Court of Appeal, it says that you have to specify the exact amount you claim due and that it's binding. And when it says that, yeah, it talks about this variance, but it says this. It says, many have interpreted the language of 627-736 to require strict construction. And then what's the second case it cites to? Chambers Medical Group as assignee of Marie St. Hilaire versus Progressive 14 FLW sub 13, the 13th Circuit appellate binding. And so he's asking you to ignore binding appellate authority in a circuit as though it doesn't mean anything, shouldn't have meant anything to Judge Ober, and it had to, and it certainly meant something to the 3rd DCA, because if this was decided today, Judge Northcutt, with all due respect, you'd have to go, yeah, I just read Rivera versus State Farm, and Mr. Dutton's 100% correct. He wins, you lose. Judge Ober's right. The fact is that the embedded basis for what is said springs from the 13th Judicial Circuit and Judge Holder's opinion in that case. And so
Judge Holder wasn't deciding in 57105. I mean, he was deciding your interpretation of the statute. He wasn't deciding 57105 issue, right?
he was not in that particular case. He was deciding
Okay.
rather whether summary judgment, which is
Right.
candidly not even a knew or should have known. You win.
Yeah, I get
Summary
it.
judgment.
Okay.
You win. And so with all due
Um,
respect, you know, I understand the point of view of 6B. I don't think that 6B requires, such as I pointed out, nor does the examination of O statute, part of the statute, nor does the examination of a person part of the statute, doesn't require that you cite that part of the statute when you're using it. And the fact that you only use part of it versus all of it, that doesn't do away with 6B. And this court, with all due respect, shouldn't extend the law to require 6B, say 6B. And we've got a number of cases with encodes in our brief on reply brief on pages 5, where an encode's use X330, the next page an encode 507. Neither of those for other carriers use the reference to 6B. Otherwise, the pre-suit demand, we should prevail, we should have prevailed, and there was no evidence to the contrary. Your Honor, thank you. It's been nice seeing you.
It's always good to see you, Mr. Dutton. All right,
Yes.
take care. In order to leave our virtual courtroom, you need to click the leave button in the lower right-hand corner of your Zoom screen. Then you'll be gone and we'll call the next case.
Judge Casanova, Judge Sargent, thank you so much.